We prepared this seminar because we think that we have a very important topic related to copyright, and especially in the class of web development or any software application classes. We talk about that, but of course we don't go as deep as we would like to go because we do not have the knowledge to do that. So that's why I'm very fortunate to have a student like Kim in my class, because then she's bringing here her husband, Marc Greenberg. So Professor Marc Greenberg is a professor of law, founding director and concurrently co-director of the Intellectual Property Law Center and Program at Golden Gate University of Law. A member of the faculty since 2000, he teaches intellectual property survey, internet, and software law, intellectual property and new technology and entertainment law in the IP curriculum. He also teaches civil procedure, business associations, and related course in the general curriculum. He was the 2010-2011 chair of the art law section of the American Association of Law Schools, and is a past co-chair of the copyright section of the San Francisco Intellectual Property Law Association. Professor Greenberg received his AD degree in English literature from the University of California, Berkeley, his JD from the University of California, Hastings College of the Law, where he served as an articles editor of the Hastings Constitutional Law Quarterly and published the first of his scholarly works analyzing the First Amendment case of the Supreme Court's 1978 term. Professor Greenberg's scholarship has focused on legal issues pertaining to content on the internet, obscenity law in online contests, and copyright issues both in the US and in China. He is presently working on a series of articles focusing on comic books, graphic novels, and the law. His articles have been published in the Berkeley Technology Law Journal, the Syracuse Journal of Law and Technology, the John Marshall Review of Intellectual Property Law, and the Loyola Chicago University Journal of International Law. Before joining the GGU faculty, Professor Greenberg practiced IP, entertainment, and business law in both transactional work as well as litigation in several firms in Northern California. He was of counsel of Chickering and Gregory in San Francisco, and was a managing partner in his own firm, Nelson and Greenberg, also in San Francisco. So I think you guys are in very good hands.
Thank you, and welcome. Thanks for coming out on this evening. My program tonight, I'm going to talk for about 40 minutes, and then I'm going to leave about 20 minutes for questions and answers. So what I'll ask you to do is hold questions until I finish the presentation of my remarks. My schedule or sort of program that I'm going to follow is I'm going to first talk about copyright law, and then I'm going to follow that with a brief discussion of the intersection between trademark law and domain names on the internet, and then I'm going to end with a discussion of how to go about negotiating terms for a web design or an app design contract. So I'm going to talk a little bit about the things you need to know if you're going to get into a contract with somebody in which you're serving as a designer for a client. So let's get started. Let me talk first about copyright. First of all, what is copyright? Well, copyright law protects the expression of ideas. It does not protect the idea itself. So that's an important distinction to understand. Copyright deals with expressions of ideas. If copyright protected ideas, there'd be one love story. There'd be one action-adventure movie. There'd be one sci-fi story because those are ideas. Instead, we got thousands of love stories because they're all different expressions of the idea. So from your context, if you were, let's say you've come up with a great idea for an app, and you want to come into my office and say, I had this great idea for an app and somebody stole my idea, I want to sue them for copyright infringement. The answer is you can't, because copyright won't protect your idea. Patents protect ideas. Trade secrets can protect an idea, unfair competition, but not copyright. Copyright protects expression. What kind? What kind of expressive works? Well, the copyright law is found in Title 17 of the United States Code, and Section 102 gives you a list of 8 different kinds of works that are protected by copyright, and I've got them up on the screen. Literary works, musical works, including accompanying words, dramatic works, including accompanying music, pantomime and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual, sound recordings, and architectural works. So just as an aside, something to be aware of, notice number 2 and number 7. 2, musical works, 7, sound recordings. What this means is that we protect sound recordings separate from musical works. The song is one thing, the recording of it is a separate copyright protectable item. What this means for you is if you're designing an app or a website and you want to use a piece of music that's recorded music, there are 2 different owners out there. One party owns the publishing rights, the rights to the song. A different party may own the rights to the sound recording. Usually in the record business, the record label owns the sound recording because they paid for it. The writer or creator of the music owns the song itself. One way to tell what the ownership is, take a look. You might have something called like a CD. You remember what those things were before everybody downloaded all their music? On the CDs, you might see a circle P and a circle C. The circle P refers to phonorecord, which means the sound recording. The circle C refers to the song. So 2 separate ownership tracks that you should be aware of. So where do software fall? Where does software fall on this list? Number 1. Software programs are considered literary works, and they have copyright protection as a literary work. Okay? But, which is what I'm saying here, source and object code in software is a literary work. Now, here's the thing. Websites and apps are bundled works. Because when you put together a website, you're putting together underlying code, source and object code, which is what makes the site run. But on top of that, you have a layer of text, textual content. You may have graphics. You may have streaming video. You may have music. That's a whole bundle. Each one of those separate elements has separate copyright protection. So as you're putting together a website, if you gather things from the net, for example, you put up a graphic you saw, or you grab a piece of video that you want to use, there are separate ownership rights to all of that. And you've got to get permission from everybody who has created any expressive work that you put on a website or on an app. You've got to get permission from them. You can't just take stuff. There's an idea floating around out there that if it's on the internet, it's free. No, it's not. Every piece of expressive work has an owner in one sense or another. All right, so how long does this last? How long does copyright protection last? Copyright protection lasts for individuals who create a work for the life of the author plus 70 years after that. Which is kind of an interesting thing because if you die young, you have a shorter term for your copyright than if you live a long time. But in any event, it's your life plus another 70 years, which is to give your heirs and those who follow after you also continuing to keep the rights to those copyrights. Now, what happens if the copyright is owned by a corporation, or in other words, a non-living person? There, the law says 100 years from the date of creation. Both of these times, it goes from date of creation. Okay? So life plus 70 for individuals, 100 years for corporate or non-human owners, and it begins at the point in time when the work is created. When a work's copyright protection term ends, the work goes into what's called the public domain. A work that's in the public domain can be used by anyone. You can take any work that's in the public domain. But here's the thing. The public domain is a little tricky. So if I were to say to you, are the works of Mozart in the public domain? You'd say, of course, Mozart died in the 1700s. Of course his works are in the public domain. So can I go to the movie that was done in the 70s called Amadeus, and can I take that soundtrack and use it? No. Why? Because Amadeus was a new arrangement of Mozart's work. Mozart's underlying work remains in the public domain, but that arrangement is protected by copyright. So you have to be very careful if you're picking something that you think is very old or classic. If you're getting it from the original source, yes, you can use it. If you've got an original reproduction of Shakespeare's quarto for Hamlet, absolutely, go for it. But if you're taking someone else's adaptation of Hamlet, that they own. So you gotta be very careful with public domain things. Also, the other thing is, I was talking about the term copyright a moment ago. I said life plus 7, right? That applies to works created after 1976. Pre-1976 works were covered by a different law, the 1909 Copyright Act, and there you had 2 terms of 28 years. It provided you renewed after the first 28 years, you got a total of 56 years protection. So, if you're trying to figure out how long a copyright lasts, so you can see whether it's a work that's in the public domain that you can perhaps use on a site or in an app, it's tricky. You have to know when the work was created and what law governed it at that time. There are companies, and you can go online and find them, that are called copyright clearance companies. And clearance companies can help you to determine whether or not work that you're going to take and use on an app is in fact something that you can access. And you've got to be very careful because copyright infringement carries some pretty severe penalties. Intentional copyright infringement, $150,000 per offense. Negligent copyright infringement, gee, I just didn't know, 30 grand per offense. So it's not something to trifle with if you infringe on someone's copyright. Now, let's talk about how you move a copyright around. Can you transfer a copyright? Can you give somebody else your copyright? Yes, you can. A transfer of copyright, to be effective, has to be in writing. You have to have a writing in order to transfer all the rights to a copyright. Now, what if you just want to give somebody permission to use your copyrighted work and you still want to keep it? That's called a license. A license can be done orally, but that's a bad idea. Because if you do an oral license, you can easily get into a fight, a he said, she said fight over what the scope of the license is, what they can use it for. And this kind of thing comes up all the time. I had a fellow once who was a photographer. He gave a license to a newspaper to use a photo in a particular newspaper story, and the next thing he knows, the paper was using it for advertising purposes and other uses that he hadn't consented to. Well, fortunately, he had a written license that said you can only use it for this purpose. But if it was oral, they would say, oh, we assumed we got the rights to use it for all these other purposes. And then it's who said what. So it makes sense to do these kinds of agreements, licenses, in writing. All right. So what rights do you get from copyright? What are the rights that you have as the owner of a copyright? Well, we find these rights in section, I think it's section 106 of the copyright law. And there are a bunch of different rights. We've got 6 different ones. I'm going to focus on a couple of them just to make sure you understand what rights you have if you have copyright protection in the work. One is, the obvious, the right to reproduce the work. After all, that's why we call it a copyright. It's the right to make copies. The next is the right to prepare derivative work. So I'm going to come back to that in a second in the next slide. Then there's the right to distribute copies. So notice 1 and 3. 1 is the right to make a copy. 3 is the right to distribute the copy. These are separate rights, which also means that if somebody infringes your copyright by reproducing it and then distributing it, they violated 2 different rights. Or you might have, if you reproduce something you don't have permission to and then you distribute it, that's 2 different claims, that's 2 different damages. So you gotta be very careful with that. Next we have 4 and 5. In the case of literary, music, dramatic, and choreographic works, pantomimes, and motion pictures, the right to perform the work publicly. And then literary, music, dramatic, and choreographic works, pantomime, pictorial, graphic, and sculptural works, the right to display the work. So one is, number 4 is the right to perform the work. Number 5 is the right to display the work. And this kind of makes sense that we have this division. Because how would you perform a sculpture? You can't. And how would you display a sound recording? You can't. So you need to have a separate right for each of these. You display a sculpture, you perform a sound recording. All right, so that's why we have separate rights for these. And then last, sound recordings is the right to perform them by means of digital audio transmissions. All right, so this is the bundle of rights that you have as the creator of a copyrighted work, like a website, like an app that you design. Now, what is a derivative work? Going back to that item number 2, what is a derivative work? A derivative work is a work based on an original work. It's taking it to a different format, recasting it in a way. So, if you're a songwriter and you wrote a classical piece to be performed by an orchestra, and then you did a jazz version, that's a derivative work. If somebody makes a movie based on a book, that's a derivative work. Any work that is derived from an original piece cast in a different framework. What we say under copyright law, because this is one of the rights you get, an exclusive right, is that if I create an original work, let's say I write a book, somebody else wants to make a movie out of the book, they've got to get permission from me. I control the right to create derivative works based on my original work. So you can't take something that already exists out there and change it without getting permission. Now there's a whole other doctrine of law, this is very controversial, called transformativeness, which in some cases might allow you to do that, to take a derivative work and add something new to it. But it's a very controversial area of the law, and boy, I don't recommend that you want to, unless you feel like gambling. You know, as Clint Eastwood would say, how lucky do you feel today? So I don't really recommend doing that. All right. One of the reasons people find derivative works controversial, though, is the classic argument is, well, look, all art comes from other art. So how can you say that if you created one piece of work, that somebody else can't take your work and create something new with it? This is a big battle in the law, and the reason we do have a derivative right protection is otherwise companies or larger groups could take, corporations or whatever, could take your original work and just run with it and do something that they wanted to without giving you any kind of compensation. So derivative work rights tend to protect creators so that their work can't be taken by somebody else to another level or in a different format without them getting some form of compensation. Okay, everybody clear so far? This all making sense? All right, good, let's move on. Let me bust a couple of myths. Now, there are some copyright myths out there that I want to bust because it's important for you so that you don't make any mistakes. The first one is what's called the poor man's copyright. Take your work, stick it in an envelope, mail it to yourself. That way you can protect it. Doesn't work. This is not copyright. It's not the equivalent of registering the work with the Copyright Office, which I'm going to talk about in a few minutes. Some people say, well, if you do that, the postmark on it shows the date. It proves when you created the work. Not really. How do I know you didn't steam that envelope open and then stick something in afterwards? All it really proves is that you sent an envelope to yourself on that date. What's in it could have been added after the fact. So that doesn't work as copyright. The other myth that's out there is, well, you can take a few notes. Can you be a little bit pregnant? You either are or you aren't. Copyright works the same way. If you take something without permission, you've infringed on copyright. It's like, well, I stole something from the store, but it was only worth $1.50. So that's okay. No, it's still theft. So no taking is allowed without consent, permission, or if it's in the public domain. You just get rid of the idea, disabuse yourself of the notion that it's okay to take any portion of a copyrighted work without permission or it being in the public domain. All right. Now let's talk a little bit about some formalities, what you have to do to make sure that you protect your copyright rights. It used to be the case before 1988 that you had to put a notice on a copyrighted work in order to protect it. If you didn't put notice on the work, it was considered going out into the public domain. That's not the law anymore. After 1988, you do not have to put a notice on a work in order to be able to claim copyright protection in the work. You can put it out there without a notice. However, it's a dumb thing to do, and let me explain why. In copyright law, if you want to sue somebody for infringing your work, for copying your work without your consent, there are two kinds of infringement: intentional and negligent infringement. Negligent means they didn't know it belonged. If you intentionally infringe, it's $30,000. That's a big difference, 5 times difference. A copy of the work has a notice on it, presumes that anyone who infringes did so intentionally. So instantly, by putting that notice on, you're in the $150,000 class of infringements instead of 30. I'll tell you what, you all offer me 5 times for the value for just putting a notice on, I'm going to put the damn notice on, aren't you? That's the difference. It makes sense to put the copyright notice on. Now, what's proper notice? Proper notice is what I show up here on the slide. You have to use a circle C. You can't use a C in parentheses. Of course, if you got Word software, it's going to automatically default to create. If you do C, paren, C, close paren, it's going to automatically default to the copyright notice, unless you turn that off, so that's a good thing. You can't spell the word out, because if you wrote it out in English, do you really have a good valid copyright claim in China? I don't think so. It's not the language of the country. But Circle C is an international symbol. So regardless of language, Circle C stands for copyright. So you have to put Circle C, you put your name, the year in which the work was created. So here's the copyright notice for the slide set. Circle C, 2011, Marc Greenberg, and then I always add all rights reserved. That's proper notice. That's all you got to do, one line. Make sure it shows up on every website you do, every app you build. Put this notice on. Kim knows I'm a real stickler about this. When we travel around, or if we meet people who've created works, I'm always looking for, make sure they have their notice on. We went to France at one point, met a wonderful chef. He was printing up these gorgeous menus of works of beautiful food that he created. No copyright notice. So I busted his chops. Hey, put the notice on. Make sure you always put notice on every work that you have, so that you get the benefit of that intentional infringement presumption. All right, now, let's talk about registration. How do you register a copyright? Copyright registration is done through the Copyright Office, and the URL for this is www.copyright.gov. Full of instructions, very easy to find, just copyright.gov. There you go. Now, interestingly, to reflect how things have changed, if you want to register your copyright and file it online, it costs you $35. If you want to do a hard copy form, $65. Do you think the Copyright Office is sending a message? Right, they want you to register online. It's very easy to do. It's a 2-page form, and there's tons of instructions. So, register work. Now, here's the interesting thing. Like I said, you don't need to register the work to be entitled to the rights of copyright, but you can't sue under federal law unless you've registered the work. So if you want to bring a copyright infringement lawsuit and get the benefit of that $150,000 in penalty, that's a federal law. You must have registered the work. Now, let me give you an even more tricky area. Suppose you find out somebody's infringing your work, you haven't registered it yet. Can you register it now? Maybe. But here's the trick. You are entitled to register a work up to 3 months after it has been infringed. Not after you discover it's been infringed, but after it's actually been infringed. So if it was infringed 4 months ago, and you discover it today, and tomorrow you file a suit, you're too late. So unless you know for sure when the date of the infringement occurs and you can add your 3-month clock running, you're running a huge risk by not registering the work. So as soon as you fix a work in a tangible form so that it can be perceived, file a registration form, $35. If you don't have $35 to file a registration form for your copyrighted work, get out of the business. Get out of the game. Because you got to spend a little bit of money to protect yourself. And $35 isn't that much. Register your copyright. Now, suppose you, as is the case with most websites or apps, as you're going along, you're building it and it takes a period of time. It might take you a year to build something. What do you do during that time? Register it as soon as you've got a first version. And then you can re-register. You can register again for the finished version. So you have protection as you're working on it. You're entitled to re-register. When you file the second registration, on the back of the forms it says, has this been registered before? And you say yes. And it says, if so, what's changed? Oh, I've added 5 more pages, added more navigation. You can list what you changed and then get a new copyright registration in the new work. Protect your work. If I have one message, if there's one reason I'm out here doing this kind of stuff, it's because it really drives me nuts when creators lose rights to their works. Protect your work. Register it. What form do you use? For the software, for the code, the object and source code, you use a form TX. The TX form covers software, object code, and source code. If you've got a bundled website where you've got video on, you might want to use, or I should say if you have visual arts, like drawings or paintings or photos, you might want to use a VA form, visual arts form, to cover that portion of the work. And if it is a full-on website with video and other film works, you might use a PA form, a performing arts form. So you might have to file more than one form for a website that has a bundle of different rights going on all at the same time. But again, $35, $70, $100. It's too little to avoid, given what you can get for that, the protection you get for that. You gotta file to cover yourself. All right. Now, you may have heard of a concept called fair use in copyright law. And what this is a right to use a work that's already out there in copyright, that already has copyright protection. You're taking and using it without permission of the author, so you're infringing. But sometimes you can argue that your use, your particular infringing use, is a fair use. Perfect example of this is criticism. A critic who reviews a work can use portions of that work without copyright infringement if they're using it for purposes of criticism. So if, for example, I want to do a review of Paris Hilton's next album, you know what? It's not going to be a positive review. I'm going to talk about what a crappy singer and writer Paris Hilton is. And if I call Paris up and I say, so, yo, Paris, can I do a review and talk about how crappy a musician you are? Paris is not going to say it's hot. She's going to say no. But fair use allows me to use that regardless of her saying no. So, fair use also is one of the reasons why your teachers at City College can pass out copies of articles or things that they've seen without getting sued for copyright infringement, because multiple use for classroom purposes is a fair use. Criticism, comment, scholarship, news reporting, etc. We have a 4-part test for fair use, which is outlined here. On the slide, we look to what's the nature of the use, what kind of work did you take? Is it a fictional work? Is it nonfiction? How much did you take? The amount, the terms we use is the amount and substantiality. What the heck does that mean? Well, obviously the amount, if you took too much of the work, that's probably not a fair use. But sometimes you could take only a small part of the work. It still wouldn't be a fair use if you took the heart of the work. That's what we mean by substantiality. So my favorite example, 400-page detective novel, you only took 1 page. the last page where we find out who the killer is. It's only 1/400th, but it's kind of at the heart. It's at the core of the piece. So you can't take that. That would still not be a fair use. And then the last and most important element is if your taking of someone else's work negates or reduces the marketability of the work, so that people no longer want to buy the original because they're looking at your work, that also won't be a fair use. The most important thing to take away from this, the thing to remember, is that fair use is done on a case-by-case analysis. You gotta carefully analyze all these elements, usually through the help of an attorney. All right, let me talk a little bit now, very briefly, about an important part of the copyright law as it applies to software and software developers. One of the things that can sometimes happen if you're working as a software developer is that you may find another piece of code, or let's say not a code, but let's say you find a site or something that you think is pretty good, and you think, gee, I'd like to know how they did that. If I can sort of reverse engineer it, deconstruct it, and reverse engineer it, then I can use this code for my site or my app. And let's say you find out that there's copy protection software that says that attempts to prevent you from doing that. Well, for most software designers and developers, that's just a challenge. Cool, I'll crack that code. And as I always say, if I want to figure out a way to crack any kind of software code, I give it to a 10-year-old because they're playing around all day. But here's the problem. The Digital Millennium Copyright Act, which went into effect in 1999, an amendment to copyright law, made that a crime. Trying to crack through a copyright software protection program is a crime. You can go to jail. So if you encounter a valid copy protection software, and of course we see this on video cassettes or DVDs, other kinds of music software and so on, where they don't want you to make unauthorized copies. Well, don't try to crack it because you'll be committing a crime. Okay, let me just briefly talk a little bit now about, I'm going to move away from copyright basics now in the interest of time and talk a little bit about trademarks and domain names. Because here's the important thing to understand. When we first started with domain names, and all of you know this, domain names weren't done in alphanumeric lettering, they're numbers. Your URL is really a string of numbers. We've added letters to that. But basically the idea was that your URL was simply your address on the web. Well, no one thought about protecting that or claiming you had an ownership interest. Do you have an ownership interest in your address? Wow, who cares? Somebody else repeats your address. But when the internet became the web, when we started to have graphics and it became a more commercial application, companies that own trademarks started to want to claim their domain name based on their trademark. And in some cases, they found that other people had gone along and grabbed that domain name. So they registered Chevrolet.com and said to Chevrolet, well, if you want it, you got to pay me. Well, that doesn't work. There's a federal law called anti-cyber squatting. And if you grab the name of something that is a valid trademark that someone else owns, and you turn around and try to sell it to them, you've committed a crime. That's called cyber squatting. So anyone who validly owns a trademark is also entitled to register the domain name in that mark. If they find somebody else has already jumped ahead and has the mark, they can get the domain name taken away. will remove your domain name if you are in conflict with a valid owner of a trademark. So trademark trumps domain names. That's the thing I wanted to make sure was clear for all of you. Now, let's talk a little bit about my favorite part, making money. How do you make money doing web design and app design? You need, rule number one, you need a written agreement. Do not design a website or an app for a friend, a family member, anyone without a written agreement, or I will come to your home and beat you about the head. Don't do it. You're inviting trouble. You want to stay friends with that person? Have a written agreement. Do not do this on an oral understanding because you're just going to get yourself into a world of trouble. All right, so how do you find contracts? Go online, hunt around. There are sample online contracts for web designers. There are books about web design agreements. There are all kinds of different resources. You can also talk to lawyers for inexpensively about the terms of your contract to make sure you've done it right. You can get a referral to a local bar, through a local county bar association. Another good group, if you're doing an entertainment or art-related site, is California Lawyers for the Arts. And their URL is up here, CALawyers4thearts.org. And they do a low-cost referral service, and you can, I think you pay $35, and you can get a referral for a half an hour with an attorney who can give you some advice on your website design agreements. Okay, so let me talk a little bit about web design contracts. There are two kinds of contracts that you need: a design contract and a maintenance contract. Okay, so you've got to be very clear about this, because design is one thing, designing the site or designing the app, but then it's not like you finished it and then you walk away. There are ongoing needs for updating, maintenance, cleaning things up, new postings. That's a maintenance agreement after the original design. That's two separate points. You can include it all in one agreement, but typically people do two separate agreements about this. Now, let me give you some key contract terms. First of all, the client who you're doing the design for will give you content. They own their content. You don't get any rights to that just because you're putting it into a site or an app. You, on the other hand, own the software program through which that app or that site operates. So there's two separate owners here. They can't use the software program without your consent. You can't use the content without their consent. So you got to understand that. There's two different owners. And obviously your contract needs to say that you're not transferring the copyright in your software to them by virtue of creating a site for them. They don't get to own the underlying software. All they own is the right to use it on the site. Here's the next very important point. This is a point that lots of software designers, website designers get into big trouble on. You've got to get all the content up front from the client before you start your design. Invariably, this is hard to do because the client is usually not together, and they say, oh, we'll just start the work and I'll send you stuff. That's a disaster, because as you're designing, all of a sudden they come in with 45 pages of additional material they want on the site that you didn't realize you had to deal with. So you've got to hold the line on this and be very tough and say, I need every single piece of content you want on this site initially. Obviously, things get added down the line. Everything you want on the site initially now. First, I don't write any code, I don't do any design, I don't do any work until you give me all the content. And you gotta be tough and make sure you get it. And you tell them. You know, they say, well, when is it gonna be done? That's always the first question. How long will it take for you to do it? Depends on when you get the content to me. If it takes you 6 months to get the content, then I'll start then. And we're 6 months behind. So it's all up to you, client. Get me your content and I start working. You also have to be very clear in your contract of what you will do and what you won't do for the client. What is the scope of the work you're going to do? Because some clients may want you, for example, they may assume you're going to host the site or the app. Maybe that's not something you're going to do. You need to clarify what you will do and what you're not going to do. You also have to talk about who's going to be responsible for testing. Alpha testing is done by you. Beta testing is usually done on site or for the client and using the client's own facility. You've got to talk about where it's going to be tested and what platforms are you testing. We used to talk about, you had to test PC and Apple OS. Now it's PC, Apple OS, and Android, and iTunes, and whatever else is out there. You need to specify all the platforms you're going to test this particular software on. Now let me talk about a couple of other key terms. Warranties and indemnification. What this means is warranties are promises you make and promises they make. For example, they have to promise that the content they gave you doesn't infringe somebody else's copyright. They didn't steal it. You promise that whatever you deliver is going to work. Now, indemnification is really important. Indemnification means whatever they give you, if a lawsuit or somebody makes a complaint about it, like let's say it's copyright infringement, they agree to provide your legal fees and pay any damages. They indemnify you, hold you harmless, because you don't want to get dragged in the middle of a lawsuit over content that you had nothing to do with. So you got to be very careful to have warranties and indemnification clauses in your agreements. The next thing, get your money up front. Don't chase people for money. Get an initial payment up front for what work is going to be done. Now, if you want, you can create a staged structure. 50% up front, 25% after the alpha site is created, 25% after the beta site is finished testing and launches. However you want to do it, but always stay ahead of the client, because the last thing you want to do is chase the money after you've done the work. So the other thing that I always suggest is get stages in which the client signs off on the work. Because if they sign off, then they're saying they approve the work at this stage. A lot of clients want to do this. Here, go ahead and build me a website and come back and, I'll come back and see what you did. I always tell a person in that situation, so suppose you came to me and said, here, build me a house. I'll build it the way I want. It might not be what you want. Same is true for the website. You want the client involved. You want them to buy in. So tell them, every stage of the work, you sign off and you approve it, and then I go on to the next stage. The other benefit of that, they sign off, and then they come back the next day and go, I want to change that. Oh, well, you signed off. Yeah, but I don't want to change it. I changed my mind. Okay, it costs you more. It's a change order. Change orders cost more. That way you avoid the client, and believe me, you get them, who tinkers, who wants to tinker and come back and, the worst thing you can do, never do this. It's a flat fee for website design or an app design. $2,000, I design your website and your app. Okay, that client is going to come back 200 times and say, would you just change this, because they figure they paid for you already, so they own you. They own your ass. Do not let yourself get in that situation. If they sign off and then you do change orders. If they want to change stuff, they got to pay for it. Believe me, they don't change as much, and they think before they sign. If they know that once they've signed, they bought it, they own it, that's it. All right. Maintenance, if you're going to do continuing work, you have to identify what are you going to do for them. If you're going to host, if you're going to update, whatever it is, you need to identify in writing what you're going to do for them and tell them how much money they got to pay. And I basically suggest they pay in advance. Well, they're always 1 month ahead. So, because you don't want to be behind and having done work that you haven't been paid for. Dispute resolution. What if you get into a fight? What if you get into a dispute? Do you want to go to court? Do you want to go to arbitration? Do you want to go into mediation? If you want anything other than court, you got to put it in the contract. There's no way to get people into arbitration or mediation if they don't want to go unless it's in the contract. So if you like arbitration or you like mediation, put it in the contract first. Attorney's fees, my favorite subject, of course. Important thing to understand about attorney's fees in the U.S. is this. There is no automatic right to legal fees. So if you get into a fight with somebody and you have to sue them, the cost of your attorney comes out of your pocket. And sometimes the cost of the attorney is so high that it doesn't make sense to sue. Unless you have a written contract that says, in the event we get into a dispute, whoever wins gets their legal fees also. A prevailing party wins gets a legal fees clause is enforceable, but you must have it in writing. Again, gotta have a written agreement. You're never gonna enforce that one if you say it's oral. Oh yeah, he agreed. Yeah, I didn't. Got their signature on the bottom line, and you know they've agreed. Should an attorney review your contract? I strongly suggest that after you've developed your first website design contract that you're going to continue to use, your basic form, take it to a lawyer, pay a little bit of money, have them review it. Go to California Lawyers for the Arts, $35 for a half-hour review. Have somebody look at it to make sure you didn't make any glaring errors. I'm done. So, how about questions? We've got about 10, 15 minutes. Yes?